Hello, dear viewers. Welcome, everyone. So, today we will be continuing our previous lecture, which was based on parliamentary privileges. And the lecture is presented by me, and I am Enaniya, Assistant Professor in Government Law College, Ajmer. So, we had yesterday studied about the various provisions with regard to parliamentary privileges in our constitution, and we had also listened to what Sir Erickson Erskine May had stated with regard to England's provision of parliamentary privileges. Okay, so these are the basic things which we had studied yesterday, and I'll just give you a brief and highlights of the same. Okay, so that you can refresh your memory, based on which we'll move further. Clear? Okay, so we know that the various powers and privileges are provided to the various members of the parliament individually, as well as the houses of the parliament have these powers and privileges attached to them. These are quintessential with regard to the performance of their crucial functions. Okay, until unless these powers and privileges are vested in them, they they are not expected to work reasonably and in a free manner. Okay, they will have various hurdles, impediments in their works. So therefore, these are the powers. Okay, what is a contempt? We understood this. Okay, since these houses of the parliament command respect and dignity, okay, then and only then the people will follow its commands. So therefore, it has even the power to punish for its contempt. Okay, and whatever impedes the performance of the function of the parliament, which lowers down its image, is contempt. Clear? The various constitutional provisions with regard to parliamentary privileges are Articles 105 and Article 194. Article 105 deals with the powers and privileges of the houses of the parliament and the members and committees thereof. On the other hand, Article 194 covers the powers, privileges of the houses of the state legislatures and the members and committees thereof. Now, we were studying Article 105, in which we had understood that the various members of the parliament have the right to speech in the parliament. We distinguished it with the ordinary fundamental right, the fundamental right provided to the people of India. Okay, so it is a special kind of right, and it is distinguished from that of the fundamental rights, and it is an extraordinary nature. Also, we had studied that the members of parliament are not answerable in any court of law with respect to whatever is said by him or her in the parliament, or with respect to the vote given by him or her. Clear? And nevertheless, no such person shall be liable for any publication which is made under the authority of the houses of the parliaments. Houses of the parliament. Clear? And now we also need to understand that what are these powers, privileges and immunities. These are the same which will be defined by the parliament from time to time, and until unless these are defined, they will be the same as provided before the coming into the force of the 44th Amendment Act. Okay, so the position of the powers, privileges and immunities is the same before the commencement of 44th Amendment Act. and the present position is, it is the same as that of British Parliament. Okay, the only difference being is the British Parliament is sovereign and ours is not, because our Parliament is a creature of the Constitution of India. So therefore the limitations are imposed upon our Parliament and it has to work within the rigors of the Constitution of India, and the Constitution of India can check the working of the Parliament, and the working of the Parliament has to pass the anvil of the fundamental right and the various other provisions as such as judicial review, etc., etc. Clear? So ours is different position, but otherwise the powers and privileges are same. So we have established that our Parliament is different from that of British Parliament with regard to the mode of creation, with regard to the operation, okay, with regard to the powers which it draw. Having said that, we must understand that other powers will remain the same. Next is the powers and privileges which are provided to the various members of the Parliament, the various members of the parliamentary committees are also provided to other people who have the right to speak in the Parliament, and he is Attorney General. Okay, so let us read Article 105 so as to have a complete insight and clear ourselves with regard to the constitutional provisions. So Article 105 reads the powers, privileges, etc. of the houses of the Parliament and of the members and committees thereof. Okay, so this is basically talking about the powers and privileges of the members of the Parliament and the members of the various parliamentary committees. So the first clause begins with subject to the provisions of this constitution. Okay, so now break it and read after the comma, there shall be freedom of speech in the Parliament. So there is an existence of the right to speech in the Parliament, but it is subject to the provisions of this constitution. So it will be subject to the power of judicial review. Clear? It will be also be subject to the fundamental rights which are provided in part 3 of the Indian Constitution. So it is subject to the various provisions of the Constitution, and wherever possible we will apply the rule of harmonious construction. Okay, first of all the grammatical rule of interpretation will be applied, and wherever we find there are ambiguities or there are difficulties in interpretation, we will go for harmonious interpretation rule. Okay, so the right to speech is subject to the provisions of the Constitution and also to the rules and standing orders regulating the procedure of the Parliament. Okay, so freedom of speech in the Parliament is subject to two main things. First is the provisions of the Constitution itself, and second is the rules and the standing orders which do regulate the procedure of Parliament. So I think our first clause is clear. Next, no member of Parliament shall be liable to any proceedings in any court. Okay, so the word court is qualified by the word any. So it gives a very broad interpretation. No member of the Parliament shall be liable to any proceedings. So no member will be liable to any proceedings. Okay, no matter what the nature of the proceedings may be, no member of the Parliament will be liable to the same. So these are the rights with respect to anything said or any vote given by him in parliament or any committee thereof. So no member of the parliament is liable to whatever is said by him in the parliament or whatever is voted by him in the parliament or the various committees. Okay, so he will not be liable to any kind of proceedings and not be liable before any court. And no person shall be so liable in respect of publication by or under the authority of either house of parliament of any report, paper, votes or proceedings. So the second part says that the right to publication is also there. So if by proper authority of the parliament anything is published, if any report or paper or votes or proceedings are there, so if they are made duly with the proper authority of the parliament, then they shall not be liable for the same. So the inference which we should draw from this positive aspect, from this positive dimension, is the negative side. So if anything is published without the authority of the houses of the parliament, then the parliament can punish for the same. Okay, so it can be either a contempt or whatever it is held by the houses of the parliament. Accordingly, the person will be punished. So the procedure of the parliament, the rules will accordingly punish the person. So I think you people are smart enough to understand from the positive inference we can also draw the negative side, and the negative inference is very much clear to you now. Next clause: in other respects, the powers, privileges and immunities of each house of parliament and of the members and committees of each house shall be as much as may from time to time be defined by parliament by law, and until so defined shall be those of that house and of its members and committees immediately before the coming into force of section 15 of the Constitution within brackets 44th Amendment without bracket Act 1978. So this particular clause talks about or provides that the powers, privileges or immunities of each house of the parliament and the members individually and the committees collectively shall be whatever is defined by the parliament by an appropriate law, and until that appropriate law is made, the position of the powers and privileges and immunities will be similar to that what was before the commencement of 44th Constitutional Amendment Act 1978. I think this is very clear to you people now. Okay. So far the position is the one which was before 44th Constitutional Amendment Act's commencement. Okay. So and that was the position of the power, privileges and immunities is the same of that of England. Clear? So whatever is the power, privilege and the immunities, whatever powers, privileges and immunities are provided with the members of the Parliament of Britain and its houses and the various parliamentary committees, the same is in Indian context as well. The only difference being is the mode of its creation and the mode of the operation. Okay, and that is our parliament is not exactly sovereign as that of British Parliament, because British Parliament is free from the rigors of Constitution and ours is not. Ours is a creature of this Constitution. Clear? This also means that the Parliament may by law provide and define the various powers, privileges and immunities. Okay? Next clause. The provisions of clauses 1, 2 and 3 shall apply in relation to persons who by virtue of this constitution have the right to speak in and otherwise to take part in the proceedings of a House of Parliament or any committee thereof, as they apply in relation to the members of Parliament. So it is denoting to those categories of people who have the right to speak in or to take part in the proceedings of the Houses of the Parliament or its committee. So it is pointing out towards the Attorney General first of all. Okay, there are other people as well who have the right to take part in the proceedings. Okay, first of all, let us read about the Attorney General. We all know that the provision concerning the same is Article 88. So let's go for it and let's read it and understand how he also has the right to speak in and take part in the proceedings of the Houses of Parliament or its committees. Okay, so basically we are concerned with the power, privileges and the immunities first of all, and secondly we are concerned with the persons with whom these powers are entrusted by the constitutional provisions. Article 88, the heading, the marginal heading is rights of the members and the Attorney General as respects houses. Okay, so every minister and Attorney General of India shall have the right to speak in and otherwise to take part in the proceedings of either house, any joint sitting of the houses and any committee of Parliament of which he may be named a member, but shall not by virtue of this article be entitled to vote. So these are two categories of people. Okay, first one being the ministers, second one is Attorney General of India. So the ministers as well as the Attorney General of India have the right to speak in and to take part in the proceedings of either houses of Parliament or any joint sitting of the houses or any committee of the Parliament in which they are named as a member. Clear? So now I think it is very clear who all are the persons who may take part in the proceedings and who have the right to speak in the Parliament. Okay, so we must also know that apart from the members of the Parliament, apart from the members of the various parliamentary committees, and apart from the houses themselves who have the powers, privileges and immunities, these are the Attorney General as well as the various ministers. The ministers can, for a period of 6 months, they can be appointed as ministers without being a member of Parliament. So it is a very clear-cut provision in the Constitution itself. So apart from the members of the Parliament, Attorney General and ministers as well can take part in the proceedings of the Parliament as well as they can speak in. Why they have this right being entrusted to them is the most important question, because until unless we understand this, we will not get the logic behind it and if we don't know the logic behind it, we might forget it tomorrow, because today you might have read and understood this, but tomorrow, until unless you remember the concept or the logic behind this provision, you might not remember the same. So, therefore, you must know that since Attorney General of India is the first law officer of Government of India, and he has a very crucial role to play with regard to the various legal opinions tendered to the government, as well as he represents the government's interest before the various courts, including the apex court. Clear? So that is why he and his legal outlook is also it is also required, and it might also be required. Okay, so the situations might arise. So that is why the Attorney General is also having the right to participate. So, and also we can never forget the roles of the various ministers who might not be members of the parliament at that particular moment, but they might get elected. Okay, so that is why these two people also are included in the list of the people having the parliamentary privileges. So thank you, dear viewers, for listening so patiently and being here, and keep the learning process going on. And I do think you are doing a great job till now. You have been so keen to gather the knowledge as much as possible. Have a great day ahead.